Why do people harass others? This is a great question. The consensus is that one harasses others to express dominance or power over them. We can downplay sexual harassment and say it is just about boys being boys. But boys being boys is actually about power, dominance, and hierarchy. Using sex to intimidate a person into a lower position on the hierarchy is obviously wrong. Boys being boys is no longer a reasonable excuse. Other factors related to harassment are related to an effort to organizationally or socially control someone. Kids, and sometimes even adults, tease one another when one is different from the rest in an effort to rid that person from the group, or to cajole that person to assimilate to the group. Other times, harassment is used to seek or gain peer approval from the group. Other times, some people are just not happy campers and they do have an axe to grind, so they bully people to feel better about themselves. Who perpetuates sexual harassment? Well, believe it or not, anyone can harass, just as anyone can be the target of harassment, regardless of sex, sexual preference, sexual orientation, age, or professional opinion. It remains pervasive in all types of occupations, from those blue collar to white collar, from agricultural jobs to those based in science and medicine and psychology. What is the difference between sexual harassment, physical attraction, and flirting? Great question. Sexual harassment is a form of discrimination, and it has nothing to do with another's physical attraction. Although this is not the all-inclusive definition, sexual harassment relates to the creation of an uncomfortable environment due to unwanted and discriminatory messages. The bottom line is that it is unwelcome and what a reasonable person would find to be inappropriate. Physical attraction is the internal appreciation of someone else's physical characteristics or other characteristics about them, while flirting is a relaxed friendliness with someone to whom you are attracted. Yes, it is common for an intimate relationship to begin at work, and certainly you should check with your company's policy about the appropriateness of doing so. But flirting can become harassment if the other person is not reciprocating your overly friendly behavior and comments. And again, it is unwelcome. It may be unwelcome, and often we don't know. Therefore, the best policy is to avoid developing intimate relationships at work. Again, remember that sexual harassment is not about attraction or flirting. It is unwelcomed behavior, a misuse of power, and it is illegal. What is the legal background of sexual harassment? Sexual harassment is a form of discrimination that violates Title VII of the Civil Rights Act of '64. Title VII applies to employers with 15 or more employees, including state and local governments. It also applies to employment agencies and to labor organizations, as well as the federal government. Now, the Civil Rights Act of 1991 and the Lilly Ledbetter Fair Pay Act of 2009 amends several sections of the Title VII, or of Title VII. So in addition, Section 102 of the CRA amends revised statutes by adding a new section following the Section 1997, 1990-81 to provide for the recovery of compensatory and punitive damages in cases of intentional violations of Title VII, the Americans with Disabilities Act of 1990, and Section 501 of the Rehabilitation Act of 1973. Many ask what protections they have if they work for a company with less than 15 employees. If this is your situation, you may have protections under state or local laws. However, surprisingly, as late as 2020, all states do not have laws against sexual harassment. If you are subjected to sexual harassment, you need to speak to a lawyer and employment attorney to determine what your state's laws are. However, if you are the recipient of sexual harassment and you work for a private company with 15 or more employees or a government agency and you want to file a lawsuit, you typically have to contact the local Equal Employment Opportunity Commission's office within 180 days. Every state is different, so make sure you look up your state after the alleged last incident of harassment. And the EEOC will make a determination as to whether you have a right to sue. Certainly, there are many other details related to your legal rights and compensation. This can be answered by the local EEOC representative or an employment attorney. Further, contacting the EEOC does not preclude the necessity for you to immediately report the alleged harassment to your Human Resources Office or supervisor or some other representative within your company. Please note that I am not a lawyer, but a psychologist, and my review of legal information is not meant to be legal advice. Let's talk a little bit about what the legal background is of sexual harassment also. So some of the history. Many of us remember the Anita Hill hearings in 1991. I know that I do, although not the first case related to the subject. This is when the idea of sexual harassment was first introduced to me as well as the masses. It was a turning point for businesses and government agencies. Ironically, during Clarence Thomas's Supreme Court nomination hearings, she accused him of sexually harassing her while Miss Hill served as his assistant at the Equal Employment Opportunity Commission office. After these hearings, reports of workplace sexual harassment doubled, and by 1997, 75% of companies had required sexual harassment training for employees. Then, in 1998, the Supreme Court ruled that companies could protect themselves from lawsuits by implementing sexual harassment training and grievance procedures. So guess what? That is just what they did. Farragar versus the City of Boca Raton, 1998, is a case regarding a female lifeguard named Beth Ann Farragar, who alleged that she and other female lifeguards were harassed by two male supervisory lifeguards who made lewd remarks and inappropriately touched them and asked for sex of Beth and other female lifeguards. Ultimately, the U.S. Supreme Court found that under Title VII of the Civil Rights Act of 1964, that an employer may be liable for supervisory employees whose sexual harassment of subordinates results in a hostile work environment amounting to job discrimination. However, the court also held that an employer could make an affirmative defense in certain situations, but these defenses are not available when the harassment ends in tangible or adverse job-related actions, like demotions or terminations. A companion case also occurring about the same time was Burlington Industries Incorporated versus Ellerth, 1998, which resulted in tighter restrictions and broadened the definition of harassment. This case involved Kimberly Ellerth, a female salesperson in Illinois, who alleged that from 1993 to 1994, a mid-level manager to whom her immediate supervisor reported made repeated offensive remarks and gestures toward her. She never reported his actions while employed, and she was promoted, but she said that she eventually quit due to the manager's unwelcome comments about her breasts, buttocks, and legs, and how her job would be easier if she loosened up and wore shorter skirts. Ultimately, the U.S. Supreme Court ruled that under Title VII of the Civil Rights Act of 1964, that employers are liable for workers who sexually harass subordinates, even if the harassed employee does not face any adverse consequences or tangible employment action. However, the court also held that employers can make an affirmative defense in certain cases. This affirmative defense is twofold, as in the Farragar case, that the company took responsible care to prevent and correct promptly any sexual harassing behavior, and then B, that the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to otherwise avoid harm.